If there's one thing that scares couples more than anything, is getting their CR1 immigrant visa denied by the consular officer. The consular officer at the US Embassy has a lot of power over your immigration case. But what happens if your case actually gets denied? What do? Well, watch this video and I'll tell you more. And welcome to our immigration channel, where we talk about everything immigration, from immigration news, visa update, and important immigration topics that you need to know to empower you in your immigration journey. My name is Jacob Sapochnik, and I'm an immigration attorney located in San Diego, California. And in this video, we'll talk about everything CR1 visas, immigrant visas, and what happens when your visa is about to get denied, you get a notice of intent to deny, or actually get an actual denial. As you know, I've done quite a few videos about embassies reopening, when are they going to reopen, the updates every month, and I'll keep doing those. But what happens when eventually you get your appointment, and at that appointment, the consular officer actually denies your visa? What do? Well, first of all, most of these denials happen for a reason. And I'm going to go over some of the reasons in this video, so make sure you stick till the end. It's very important to know some of the recent denials that are coming from a lot of these embassies for you to be prepared how to overcome them. Remember, there's a reason for every denial, and most denials can be overcome. So don't stress out, and remember, this is not the end of your immigration journey. So first things first, after receiving a denial of your CR1 visa, you will have 1 year to provide more documents to try to overcome this denial. My recommendation is to try to respond to this as soon as there is a denial of that CR1 visa. Make sure you provide them any additional documents within 30 days. If you don't provide any more documents within that 1 year, your case will close and you're going to have to start all over again. File the I-130, go through MVC, and end up at the interview again. So make sure that if you have more documents, if you have sufficient reasons to overcome that denial, make sure you act on it within the first 30-60 days after they issue that intent notice to deny. So let's talk about the top reasons for CR1 immigrant visas, reasons for denial. It's better to know about those reasons in advance so you can avoid making those mistakes in your own case. Remember, it's important to think about those things in the early stages when you put together your I-130 package, the immigrant petition, from the early stages, what kind of evidence you put and what information you put on the forms to avoid any future denials. The number one reason for CR1 immigrant visa denials is not meeting the income requirement for the affidavit of support. The petitioner must show that they can financially support the immigrant by filling out the I-64 affidavit of support, and they have to meet the poverty guidelines, 125% of the poverty guidelines, to be a qualified sponsor. If you don't meet the income requirements, you have to find a co-sponsor, somebody that can co-sign the form as a co-sponsor that has sufficient income. Once again, this is one of the most common reasons for visas to get denied. When people get to the end of the interview and they still didn't meet the income requirements, the consular officer has no choice but to deny the visa petition. Number two, the second reason most of these CR1 cases get denied is that the consular officer is not convinced that it's a bona fide marriage. There's not enough evidence to support the fact that it's a real marriage for immigration purposes. So they want to see more joint documents together, maybe chat records if the couple is living in different countries. More documents you can show that it's a real and bona fide relationship by showing the documents, pictures, keeping communication if you're living apart. The more you'll be able to convince the consular officer that it's a real marriage. The third reason that most of these CR1 cases get denied is that the consular officer finds you inadmissible to enter the US. Some of these reasons that they find in the interview is previous overstay more than a year, subject to a 3 or 10 year bar that were not addressed before the interview, falsely claiming US citizenship in the past, being accused of immigration fraud or any misrepresentation in the past, or any other reason that a consular officer determines that you are inadmissible to the US. In the case that you determine to be inadmissible, there are certain waivers. The most common waiver is an I-601 waiver, and we'll do a separate video to address that waiver. So what do you do if your CR1 is actually get denied? It's very important to review the denial first with an attorney to make sure that you understand the real reasons why it was denied. Sometimes it's worth contacting the post as well. In many cases, we are also able to use congressional assistance to allow us to inquire with the case. But again, If you're deemed inadmissible, of course, a waiver will be needed, and at that point, the consular officer will recommend a waiver. Depending on what the reason for your denial, if it's an inadmissibility, you can do a waiver, but if there are any other reasons, you really have to consider whether you should refile everything from the beginning or submit more evidence to the consulate if you feel that it's just a few things that you can do to fix this, to be able to get your visa within that 1 year. Hopefully this information was helpful. Let me know in the comments if you have any questions about CR1 visa denials or if you're concerned about your case. Once again, don't forget to subscribe to our channel. Also give us that like to make sure that YouTube will share the video with more people just like you. Thanks for watching, and I'll see you in our next video. Watch these two videos for more information just like that.